Hello and welcome to this week's episode of Chaile Time. Haven't seen you in a minute. There's a lot to unpack. Welcome, Toby. How are you?
Welcome, Tsepo. I'm well. I think I must open your office there in KZN.
Yeah, I must stay there. Plus, it's warm there. It's nice.
Oh, yeah, it's nice and warm.
Yeah,
it's just
nice
really
and
cold
warm.
here, this side. But you've been busy, eh? Hey?
Hectic.
Big case yesterday in KZN. Where was this MEIBC?
Yes.
With the unions?
Yeah, but it took a quick turn.
I really thought, I booked your flight. I think you flew back like 8 o'clock in the evening or something.
Yes.
I really thought yesterday you sitting there
The whole day.
It was like an hour and it was finished.
1 hour and then at 10 o'clock we were out of there.
I share that, yeah.
Not even an hour, it was 30 minutes because the commissioner only arrived at 9:30.
Okay.
We sat there for 30 minutes. 10:10, we were out of there.
And the dispute had like 20 employees and only 3 pitched up.
3 pitched up and then they're like, you want me to call everyone here? I'm like, no, I'm just asking if all the people are still interested in this thing. But the commissioner did the most for me. What have you been busy with?
Well, the Harmony People Network conference, it's been consuming me, all my time, all my effort. So we are having I'm sure everybody knows by now, we're having a very exciting Harmony HR conference in KwaZulu-Natal, Cape Town and Gauteng next month. So, but yeah, if you are interested, we're having great speakers, keynote speakers, Anja van Beek, Vanessa Botha, myself, part-time commissioner, Clarence Randall from CCMA. It's going to be a great networking opportunity. We're having an IR workshop presented by myself and the part-time commissioner, Clarence Randall from the CCMA. And then I think a South African first, it's over 2 days, but the second day, it's going to be a stage arbitration live. We're having the comrade there.
Amandala.
We're going to have the commissioner there, and we're going to have myself there. And we're going to unpack a lot of jurisdictional matters. We're going to go through a live case. It's going to be freaking awesome. But if you want to know more and want to register, we will put the link at the bottom in the description here. So just open it up a bit there. There will be a blue link there somewhere. Click on it and you'll see all the information, the program. And yes, it costs something. Get your boss to pay for it. If you are in HR, or in operations, in management, or you're a supervisor and you are involved in CCMA cases, you must attend this. You'll also get a certificate of attendance, so it will be great for your CV. But this is a one-time opportunity for you to learn in a safe environment where there's no real cost involved from an arbitration award perspective. How to learn IR, how to learn how arbitration works. Tsepo, what people don't always realize is that there are so many, and you know this, jurisdiction, you love jurisdiction. This is one thing in the last 2 years, you've really learned a lot, all the freaking jurisdictional issues there are in the book.
There's another one coming soon.
But Tsepo, yesterday, a big company, one of the big pillar companies in South Africa, HR manager or IR manager contacted me. They've got a case today. This employee filed an unfair discrimination dispute, and can I just give some tips on how to approach this? Because this employee actually never filed a grievance, and she never tried to resolve the dispute, and she just went off to the CCMA because most it's your right, no?
Yes.
Now, once again, it's got to do, what I'm saying now, it's got to do with jurisdiction. A lot of people think they know how to fight the case at the CCMA, but they are ignorant of the hidden jurisdictional matters that can actually benefit them if I knew about them. And that is what we're going to help you in this in the IR workshops and the arbitration and the conference. So, I just informed, I copy and pasted, I took a photo of the Employment Equity Act. Section 10, subsection 4B of the Employment Equity Act actually say, as far as disputes on unfair discrimination is concerned, that when an employee files a dispute to the CCMA, they must satisfy the commission, which is a CCMA, that they've tried reasonable attempts to resolve the matter internally first. Jurisdictional issue. Technically, it means the CCMA can't entertain a dispute if that employee never spoke to the employer about it. So you need to know about the pitfalls.
So your attendance will be very important there. Be there or be told, because it's a one-time golden opportunity.
Yeah, it's going to be great. South African first. It's going to be awesome, and I'm looking forward to it.
Okay, except for that, there's something that I want us to highlight.
Yeah.
Or I don't know if we're going to talk about it.
Well, I'm talking about credibility today.
Okay.
I think this is going to be a Chaile time that's going to be running over the 20-minute deadline, so it's going to be a bit longer. I'm just hanging there. I think this is great, but what do you want to highlight?
No, the case that we went for last week.
Which one is that? There's so many. Which one?
The one we went together. We never go to a case together unless...
I'm turning 50 this year. Case last week. We went to a case together last week.
Last week we drove together. When was last time we drove together?
Oh, that was for... Oh, that case in CCMA Johannesburg. Okay.
I just wanted you to highlight us on the how many hours you spent there just narrowing down issues.
Well, we spent narrowing down issues from 9 o'clock to 12 o'clock. Now, I was the company representative and you were the company witness because you did the initial, very complicated case actually. It's a case whereby it was a misconduct case, with the outcome was reserved because they knew ventured into incapacity matter, to see whether this is not really an incapacity case. They didn't convert back to the findings of the misconduct. So ultimately, the employee was dismissed for misconduct, but Tepo.
I love the facial expression.
Yes, see, that commissioner was. You know what, man? When I studied labor law at University of Pretoria, they told us that the commissioner at the CCMA is like a chocolate in a chocolate box, a box of chocolates. You don't know what you can get. Yes. You know those chocolate boxes, and you open it up. One is round, one is triangle, one is square. You just don't know what you get, huh? And this is this commissioner. He get offended so easily, and he gave us shit. Man, yo, pre-op. So he wants to do pre-op now. So I tried to do pre-op with the employee, but the employee didn't trust me. Look, the employee don't know. He doesn't understand law and where pre-op is coming from and what.
Because he can't afford an attorney.
Yeah, I can't afford an attorney. Anyway. So he just said that, look, he doesn't trust the process. Let's wait for the case, okay? So now the commission is trying to help us with pre-op, no problem. But now the employee is saying, now, part of the pre-op process, the main purpose really is to see what are the issues that we all agree on and what are the issues in dispute which the commissioner must then determine, okay? And that is to shorten the process. So those pre-op minutes are legally binding, so you don't discuss those matters really, they are an agreement, it's common cause. So this employee, the commissioner asked me, so why was he dismissed? So I said misconduct. But I also brought to his attention the whole dotted line investigation to incapacity. The employee then stated, no, but he's got a problem with the misconduct process as far as what was the issue? Oh, you as a chairperson did not allow him. He asked, you want to bring certain witnesses in, and you said, no, you can't have them. Which is not true anyway, but that was his issue. Yes. But now I can see his file is this thick, and 90% is medical reports. So I can see this guy is ready for an incapacity warrior. And he's very confused. He's not legally trained. So he's the kind of person, in my judgment, that can agree something on pre-op and then venture into something else. And at that time, the commissioner already fought with him 10 times. So the commissioner already got full of this guy, you see. But no, he didn't leave me out when he said. The commissioner gave me my whip also, So at the end, commissioner asked me, okay, so we're done with pre-op now. Mr. Nel, do you have anything you want to add? So I said, Mr. Commissioner, as part of the process of, see if we can't agree, what the matters we agree on, I just want to hear from him. The employee now, does he actually agree that the misconduct process was the correct process? Because there's this legal-wise case now where they've dismissed an employee for misconduct and the court eventually said it should have been the incapacity process and they got a bit of a beating. So I've got that in my mind. So I want clarity, Does he actually agree this case should be misconduct? Oh my goodness, that employer gave it away. But you've told me the issue is misconduct. You told me he was dismissed for misconduct. And he said he's got a problem with the chairperson not allowing him to have witnesses. So I said, I understand that, Mr. Commissioner, but I just want him to agree or disagree that the misconduct avenue itself was fair.
Yeah.
Because, if you retrench somebody, you don't follow the misconduct process. You may have an issue with what happened on the day of the misconduct process. But was the misconduct process the correct process if you want to retrench staff? No, that's just that's not this what's happening here. I'm just giving this an example. So you also need to understand whether the actual process followed, whether we agree in context of a pre-op now. That commissioner just didn't understand. He didn't understand me. So I'm just like, Mr. Commissioner, if you can see in his file, 90% of the stuff is incapacity. I don't want us to agree that the misconduct process is fine here, and then later he ventures into incapacity. Commissioner was just so angry with me. He just didn't understand me. Now I was just like, what is really so difficult? Either the guy say yes, he agrees the misconduct process was indeed the correct process after he's been explained what it means, of course, or he doesn't agree. At least we know. He gave me shit at commission. But then secondly, yes, this is going to be a long challenge. Then secondly, at some stage, Seppo, you were testifying and it was cross-examination. The employee cross-examined you. But yes, he was struggling. And yes, I understand. I don't have a problem if a commissioner helps out a bit and venture into the arena a bit. But there's also limits.
Yes.
But this commissioner, he just interfered. He stopped you and he started leading this man in evidence in chief. So asking him questions, sucking out information out of him. And it went on for like 20 minutes and eventually I'm like,
excuse me.
Commissioner, I just want to ask, considering this is now cross-examination supposed to be, and I was humble, man. You're now leading evidence out of this man, and you're writing all of this down. Oh,
Mr. Nell, are you insinuating anything?
He actually said I insulted him. I am condescending. He didn't say this, but I was thinking he's going to say I'm a racist. I was waiting for it, but he didn't. But I was insulting him because never ever had I had a problem the whole morning if he writes things down. So I said, Mr. Commissioner, the issue is not you writing down. The issue is you interfering in cross-examination and drawing evidence in chief out of this guy and writing down. And my concern is it may find its way to the arbitration award. Because you see, here now, I'm a bit damaged now. I was involved at a case in CCMA Witbank a number of years ago, where after arbitration, the commissioner and the lawyer stood casually in a corner with the applicant, chatting. I went to stand there with him, and the stuff discussed there found its way in arbitration award, and we lost the case. So I'm like, will decisions now be made based on this here now? And I don't even get an opportunity to cross what he is saying, He just didn't allow me. He just shat all over me. So I was just like, but you know what, Chaile, still, I did not get the sense that this commission is unfair.
Because he was doing it.
He was doing it more with the applicant. So I still felt the commissioner is fair. And he's one of those commissioners he's very detailed. He's very thorough in what he does, but he doesn't take shit.
Yeah, because
But I have a problem. I don't think he understands what I'm trying to say.
Because
either I don't communicate right or he really is lost.
the employee will go for 5 minutes speaking alone with me. They're sitting there waiting for him to ask me a question, and he will come on and on and on and on and on and talk about this man. He talk about this, and then he takes out his pills. Anyway, the case is almost
done and we haven't started.
Anyway, that case is not done, so it's been postponed. So, what are we really talking about today? Sorry,
I've got a long case here now, but now we're going to have to do this very shortly. Okay, so some time back, I spoke about a case where I represented an employee against one of the large pension fund houses in South Africa. Now, we can't give names, obviously not. But in this case, the dispute was whether a contract of employment came into existence in the absence of a physical contract signed. So this is high-level people. This person was recruited as a head of investments in this organization. And there was a lot of discussions on email between him and the other party, the employer. But there was never a physical contract signed, and there was never an official starting date. So, by law, is the contract that a tacit contract that came into existence, yes or not? And him not getting the job ultimately was that is that considered to be an unfair dismissal. So we received the award, and we, from the employee party, we're back short after this. Okay, we're back. We lost the case, Seppo.
Yes.
We lost the case, but a very interesting case. And I'm just giving an overview now. In essence, I gave this in my view, and I think in the Commissioner's view too, a brilliant legal argument. And the Commissioner said, you know what? I have no problems with my legal argument. He agrees with my entire legal argument, but we still lost. I gave him all the freaking legal elements as to why that contract came into existence, but ultimately he made a decision based on the credibility of my applicant. And based on that, he went with a version of the respondent, the employer, and we lost the case. And I'm just like, oh man, if we could have just fixed that credibility issue, you know?
Then you could have.
Yeah. So, okay, just in a nutshell, so we can all learn quickly. So in this case now, this employee applied for a head of investments positions at this large prominent fund house in South Africa. And he reached out on LinkedIn to the CEO, and he said that, look, I see that this position is available, but the time of application expired. Can he still apply? So she said, yes, just send your CV to the HRBP, which he did. And then HRBP, they had an e-meeting with him, which went well. There was 2 subsequent interviews set up, which went well. Now, everything happened on email. There's a lot of things that happen on email. He asked her, you know, so how did it go? And she said, no, he's the successful candidate. So that made him an offer in terms of salary range. He said back he accepted the salary. He then asked, but listen, can you just give me a dummy payslip so I can see, you know, how it will look like? And she said, yes, I will do it. And then the contract, he said, they told him, look, the contract is being signed by the executive, so it will come out soon. And then they sent out a meeting invite that said, introducing head of investments, and sent it to executives with him. So they now introduced him as the head of investments that's been appointed in this position. And the next moment, he got a call that there's been a merger between this company and some other entity, and he no longer, the position is no longer available. Is that a contract that came into existence, yes or no? There's 2 versions in essence. The one is that yes. Now look, you must remember, a commissioner don't know what really happened. They're dependent on what's been put to them on the day. So on the one hand, it's our version. There was an e-meeting, 2 interviews, in writing confirmed he's a successful candidate. He's been introduced as the new head of investments. He was made an offer financially. They agreed to give him a dummy pay slip, and they said the contract basically is just a formality. They're issuing the contract, but which they never did. So that is our view. So therefore, there was actually a verbal/email kind of agreement to employ. And even during cross-examination, the HR manager, because we subpoenaed them, confirmed that had it not been for the merger, he would have been employed. Also, there's no disclaimers in the emails, nor did they tell the applicants that, listen, a contract of employment only come in existence if all terms and conditions had been agreed on. Because in this case, there's sort of an agreement on salary range, and it seems like there's an agreement to employ. But other terms and conditions of employment was not agreed on yet, in terms of benefits and all the other T's and C's you normally find in a contract of employment. So is it enough to say, listen, there's an agreement to employ, but all the other elements has not been agreed on? Now, there's nothing in the disclaimers to say a contract of employment only come into existence if all the T's and C's have been agreed on. So our view is there's been an agreement to employ. You know, he's already been introduced to the team, and he had the meeting. He's been introduced as the new head of investments. There was money put on the table, which he agreed there. On the emails, the HRBP said, yes, you are the successful candidate. So that's our view. Their view is he fabricated everything. He tried to create a contract of employment that doesn't exist. And this is where the issue is coming in. Oh, man. Right in the beginning, before I got involved, he had another attorney, and they wrote a letter of demand to the employer. And the very first sentence says that our client was headhunted, which is already a lie. Because then the advocate from the respondent showed in the bundle of documents the LinkedIn messages. He reached out to the CEO of the company.
Even after the closing date.
Even after the closing date. So there's no headhunting.
Yeah.
Secondly, the CEO said they discussed this one position. And when he eventually sent the CV to the HR,
yeah.
he said the CEO said I must apply for 2 positions, which is already a lie. No, you didn't tell me that stuff before when we prepared. You see, I didn't know about it. You find that out. You know, when you represent employees, you get their version of the truth, which you find out on the day.
Yeah, you'll see on series like Lincoln Lawyer and those kind of things, you know, on the day when you go to court for trial, and then boom, there's something coming out, and then the lawyer will be like, but you did not tell me this.
No, you don't tell me this. No, okay, shit, yeah, okay. Anyway, so now their version went further. The salary that was on offer was a range. It wasn't specific, you get 10,000 a month. It was between 10 and 20. You saying a set, you want to create the idea there's no contract that came into place here. They were just busy discussing to test you if you will be happy with the range. No formal offer was made, a specific offer. The whole issue about the payslip, you're the one who asked for the payslip. They never said they're going to make the payslip. But now obviously they agreed. So our view was, okay, you know, when we had our case, I heard their view and I'm like, okay. But at no stage did the HR challenge, hey, you're having the wrong idea. You don't have to accept anything. I didn't make an offer yet. So where do you draw the line? Yes, he's the one who asked for the payslip. But why will she say yes to the payslip if it wasn't her understanding that there was a contractual agreement here that took place here? And the head of investments meeting, it wasn't to introduce him as the head of investments. It was just a general discussions as to how this can look like. Whatever, hocus pocus that may be. It's, you know, some of these views were quite laughable because the fact of the matter is, how do you have all these things in place? But it was never your intention to make the offer in the first place. You actually didn't do it. And you didn't challenge because he say, I accept your offer. And you didn't say, hey, I didn't make an offer yet. You're understanding me wrong here now, no? So where does the commissioner draw the line? Anyway, but before I go there, where drew the line, I just want to touch base quickly on my closing arguments, my legal arguments, and this is more from an educational perspective. So, you know, on this question about whether a contract of existence came into being, even though a contract of employment had not been signed yet, I think I want to make my starting off point Section 29 of the Basic Conditions of Employment Act. This is chapter 4. This actually deals with written particulars of employment. So if you want to know where in the law does it state a contract of employment must be given to an employee, it actually doesn't use, the law doesn't use the word contract of employment. It uses particulars of employment, okay? And it's interesting, basically, a contract exists of 2 parts, really. In principle, the one part is what's required, the minimum requirements of the law. And here you have point A to point B, okay? That must be in every contract. And then the second part is the wish list, you know, the confidentiality agreements, all the nice stuff the employer wants in there. There's nothing here that says there must be a confidentiality agreement in the contract. There's nothing here that says there must be a restraint of trade, okay? This is the law requires basic things, the name of the employee, the addresses, your shifts, your pay, you know, these kind of things, your benefits, all the basic stuff, you know. With other words, the first 2 pages of the contract is what the law requires. The other 100 is all the nonsense that the employer wants. Okay. It's interesting, it says here in Section 29, written particulars of employment says, an employer must supply an employee when the employee commences employment with the following particulars in writing. So the law doesn't say you must give somebody a contract of employment before they start. You see this case now with us. They're saying, but we never gave you a contract. But the law says you don't have to give me a contract for the relationship, the agreement to exist. That normally follows after you've been employed.
After the commencement.
So the law already created that basis, you see. Yes, so this is becoming a difficult case. But anyway, just some highlights quickly from my side. I'm going to mention some case law here. In SA Metal Limited, Pty Limited versus Holroyd, the court found that for an employment relationship to exist, a written contract of employment is not necessary. It should further be noted that the labour legislation does not refer anyway to a contract of employment, as is common practice in companies today, but does provide in Section 29 of the Basic Conditions that employers should, upon commencement of employment, issue the employee with written particulars of employment. For all intentional purposes, the legislator knows that employment agreements are entered into between employers and employees without all the terms and conditions of employment having been fleshed out on that, and that these, including precise details of remuneration and benefits, will follow upon commencement of employment. So typically when there's an interview or discussion between an employer and a potential employee, you discuss the base, you agree on the fact that you are employed and you start maybe on a certain day, or you are entitled to start, and maybe salary. My wife got a job offer 2-3 months ago. She only found out what the salary was payday a month later. They never discussed anything. She knew the company. She had no idea what they're going to pay her. They just said you start on this day and there you go. I actually asked her, what's the pay? She doesn't know. She found out payday. Really? Are you telling me there's no employment relationship now because we didn't agree on the pay? You see, you can agree that I'm going to recruit you, I'm employing you, without the detail. Okay. Novartis, South Africa versus Marpil Trading. The Supreme Court of Appeal found that in interpreting contracts, there is a factual matrix of all the circumstances and the context that must be taken into consideration, ascertaining the intention of the parties, what they meant to achieve. Further, in Novartis, the court found a further principle to be applied in a case such as this is that a commercial document executed by the parties with the intention that it should have commercial operation should not lightly be held unenforceable because the parties have not expressed themselves as clearly as they might have done. So sometimes there are commercial agreements, but they didn't flesh out the exact detail. It doesn't mean that agreement is now null and void. Because the reality of the matter is, from a commercial perspective also, but same principle. I put it forward that the same principle should apply in labor matters, because it's really the same thing. Often there will be a discussion around the table on businesses working together, but the in principle agreement is done. The lawyers don't sit there, right there, and draft all the documents and everybody sign off. No, that happens a few months later down the line. So just the fact that the documents weren't signed, it doesn't mean this agreement here on the table means nothing. It's unenforceable necessarily. Unless, of course, if there's a stipulation or a provision in that agreement that this agreement is only enforceable when all T's and C's had been agreed on and signed off. So that's why it's maybe advisable that if an employer wants to consider the existence of an employment relationship only after the contract employment had been signed, maybe they should have a disclaimer on their email when people apply for jobs to say, listen, don't think there's an expectation to an employment just by the fact that we may have reached or achieved some kind of consensus in our interviews or discussions.
In terms of our engagements and those kind
only
of things.
After the following things had occurred can you say there's an agreement, you know. And you know what? Was it not for the credibility issue with this client, I think that company may have been in serious trouble. Big money. In Corbett JA, in CGEE, Altsom Equipment et Enterprises Electric, South African Division versus GKN Sankey, the court held There is no doubt that, where in the course of negotiating a contract, the parties reach an agreement by offer and acceptance, the fact that there are still a number of outstanding matters material to the contract upon which the parties have not yet agreed may well prevent the agreement from having contractual force. A good example of this kind of situation is provided by the case of OK Bazaars versus Block, where the law denies such an agreement contractual force. It is because the evidence shows that the parties contemplated that consensus on the outstanding matters would have to be reached before a binding contract could come into existence. So what I'm saying again here is, it could be, but only in the circumstances where it's common cause, basically, that only when all the T's and C's had been agreed upon, only at that stage the contract became binding and enforceable. Okay? If that didn't happen in that context, then obviously, the initial agreement is null and voided. But that's not necessarily always the case, especially not in labor matters, because here the basic condition actually envisions a situation whereby contracts are only entered, physical contracts are signed after you've already reached the contractual agreement in principle. The existence of such outstanding matters does not, however, necessarily deprive an agreement of contractual force. The parties may well intend by the agreement to conclude a binding contract, while agreeing, either expressly or by implication, to leave the outstanding matters to future negotiation with a view to a comprehensive contract, like my wife, dotted line. In the event of an agreement being reached on all outstanding matters, the comprehensive contract would incorporate and supersede the original agreement. If, however, the parties should fail to reach an agreement on the outstanding matters, then the original contract would stand. Interesting. Okay. How did the commissioner so how did the commissioner eventually came to his decision? Taxels. What he did is applied the Stellenbosch winery case. I think it was good. I think the commissioner was he was what they say, he was in a catch-22.
Yeah.
Okay. So basically, in Stellenbosch Farmers Winery Group Limited and another versus Mattel et CIE and others, the Supreme Court of Appeal said the following: the court held that was a commissioner is faced with two conflicting versions before him, the commissioner must make a finding on the credibility of the witness and on the probability of the two versions to determine where the truth lies. The question that should be answered is whether the probabilities favor the party that bears the onus of proof. So in this case, obviously, the applicant bears the onus to prove. Now you have the credibility. Even though technically, I suppose, what the company's witness, look, we had 5 people subpoena. We ultimately only used the one witness because everyone was focusing on the credibility of the applicant. So I was just like, oh my goodness, this is going south. But anyway, even though technically what happened from a company perspective leaves much more to be desired, the fact of the matter is their witness was brilliant. Just in the terms of innocence, and she didn't create the impression that she was trying to be malicious or devious. Okay, technically I suppose they made mistakes in my view, but my client was clearly devious. He was like a snake trying to sneak himself into a company from the very start. So if you've got two brilliant arguments, how do you choose? The credibility of the witnesses. And we had no credibility. That witness, the applicant, oh man.
Mr. Headhunter.
Yeah, Mr. Headhunter. So here's the lesson. Don't try to cheat yourself through life, man. Hou die blink kan bo sê hulle in Afrikaans.
Yeah, you're going to be caught out.
You're going to be caught out, man. Yes.
Now he left you like you were the Lincoln lawyer.
Now you're sitting there. Most of the witnesses I can't call because everyone is like, yeah, he's a thief. Like, oh my goodness, how do I get around this thing? I mean, just see.
Yeah, I know.
And the scary part is now we prepared properly. Even we went through the lawyer's letter and he stuck to his version. I only found out on arbitration all the evidence after the discussions between him and the CEO of the company before the time and how he tried to sneak himself into his business. But still, Tsepo, my question I'm still asking is, you can be devious, right?
Yes.
Does that take away the fact that there was a contract? Not necessarily.
No. Hence, the commissioner also went this route.
You see, that's the thing. The commissioner ultimately
Because you
don't
can
know,
see-
and then you need to use tools to the best of their ability.
Yes. On the outcome, he even stated whatever that you stated and all the case laws that you quoted and everything.
What I didn't read, he said there, I accept all my legal arguments.
Yeah. The problem was,
The problem is he didn't use it. He used the other party's legal argument, which said we were like a snake trying to create a version that doesn't exist. Anyway, this is a long one. So, but anyway.
yeah. Thank you for watching. I hope you've learned on this one. Yes, it dragged for quite some time. Don't forget to like and subscribe, and don't forget to click on that link if you want to join us for the HR concert next month.
Yeah, the conference next month, you must join us. It's a once in a lifetime opportunity. You want to learn, impress your boss, become a bit more clever than they are, have something fantastic in your CV, join. And don't pay for it yourself. Get your boss to pay for it.
Yeah, you know, he's gonna pay for me. So yeah. Thanks for watching. See you next time. Bye.